Monday, 5th May 2019. The time is 6:09 p.m. I'm Maham Siddiqui and this is my co-host Siddharth Shukla on the Australian Broadcasting Company. The High Court of Australia has declared that the Australian state can no longer use the concept of terra nullius to continue to justify colonialism of land in or outside Australia.
For those people who are wondering what terra nullius is basically it is a legal just equivalent of saying finders keepers. And basically, in this case, Captain James Cook set sail from England around 200 years ago, and he found a land which was, according to him, uncolonized by any other people. In the process of doing so, they ignored the fact that this land was already inhabited by hundreds of thousands of people who had their own culture, their land, their own system of law. And these people's system was replaced by the new European civilization. The European colonizers deemed it appropriate to literally take over the land violently and by other more subtle means that resulted in the near annihilation of the indigenous people and the culture.
You're absolutely right. And terra nullius was the legal concept that made this possible. It allowed the colonizers to take over the land from the indigenous people and use it for their own colonial pursuits. In this light, the judgment of the court is really significant. But what does this really change? Let's go to our correspondent from Perth, Mr. Kataria, to know more.
Thank you, Maham. I'm standing in the famous city of Perth, Australia, and as you can see, there are absolutely no signs of civilization here. All the buildings, parks, and the markets have been demolished, and the control of the land has been given back to the Aboriginals. As you can see, the Aboriginals behind me are dancing and enjoying their lives. Their children are playing in the Perth cricket ground. It's all hunky-dory here. Back to the studio.
Of course, that does not just happen. The Australian state did not just give up all their land to Aboriginals.
But that should happen, right? If the state agrees that it was someone else's land that they had encroached, it should be given back to them.
Yeah, and that something has been done by the Australian Parliament. It's called the Native Titles Act. According to this act, an Aboriginal can now apply to the state to claim their land, which was taken away by their colonizers. Claim their land. That's where they all went wrong.
See, the thing is, the natives never claimed their land that it was as theirs. Rather, they were of the opinion that they belonged to the land. They see themselves as inseparable from the land and the nature and were merely its caretakers. They do not have any concepts like title over the land.
And there are practical considerations too. To claim land under the Act, first the natives will have to prove that they are natives, which is increasingly difficult because of the crossbreeding of the Aboriginal people with the white European settlers. Also, they need to present evidence that the land in fact did belong to them at some point, which is again stupid. If they never claimed title over it, they would obviously not have any property papers for the land that could prove title in a court of law. All they have are folklores and mythological tales about God ordaining them as caretakers of the land.
All in all, it is almost impossible for the native to claim the land as it was inhabited by their ancestors. In fact, it is more likely to initiate scuffles between groups over natives who could be claiming the same land.
Basically, the new law does nothing for the Aboriginals. They don't get to enjoy their land again and they don't get any reparations. It does nothing.
Oh, it's a plenty might. For the government, it does everything. It gives them an easy escape route out of the guilt of their horrific past. The whole world will pat their back and the actual root of all evil, Australian state sovereignty. It remains stronger than ever. And guess what? When none of this land is claimed by any natives, the government will have the power to give it to multinational corporations and earn heavy revenue from itself. So, drink beer and cheers, mate.
In the news are tonight, talking about the judgment that achieves nothing. The judgment of Australian High Court in the case Kruger versus the Commonwealth was another such judgment. In this judgment, certain natives constitutionally challenged the Northern Territory Aboriginal Ordinance 1918, which gave the government power to remove at will and by force Aboriginal children from their families to be placed in missionary schools, orphanages and foster families to save them. Yes, you heard it right. To save these children.
Basically, the logic was that half-caste children who resulted because of breeding between the Aboriginals and the white population need to be saved. And how did they do that? By breeding out the native gene. They were designated officers called the Chief Protectors who undertook this task. Let's take a look at what they did.
State comes under my control. Notice, if you will, the half-caste child. And there are ever-increasing numbers of them. Now, what is to happen to them? Are we to allow the creation of an unwanted third race? Should the coloureds be encouraged to go back to the black? Or should they be advanced to white status and be absorbed in the white population? Now, time and again, I am asked by some white man, if I marry this coloured person, will our children be black? And as Chief Protector of Aborigines, it is my responsibility to accept or reject those marriages. Here is the answer. 3 generations. Half-blood grandmother, quadroon daughter, octoroon grandson. Now, as you can see, in the 3rd generation, or 3rd cross, no trace of native origin is apparent. The continuing infiltration of white blood finally stamps out the black color. The Aboriginal has simply been bred out. Now, we come to the Moore River Native Settlement. Ladies, most of you are familiar with our work here, the training of domestic servants and farm labourers. I would like to thank you for your continuing support. Hundreds of half-caste children have been gathered up and brought here to be given the benefit of everything our culture has to offer. For if we are to fit and train such children for the future, they cannot be left as they are. And in spite of himself, the native must be helped. Now, this report from Constable Riggs about the 3 little half-caste girls at the Jigalong Fence Depot, Molly, Gracie and Daisy. The youngest is of particular concern. She's promised to a full blood. I'm authorizing their removal. They're to be taken to Moore River as soon as possible.
Don't move.
There's nothing you can do here, old girl. Nothing you can do.
Or such benevolent people. All they are doing is saving these native half-caste children. What was possibly wrong with that? And look at the natives challenging this act as being paternalistic. Good Lord.
All jokes aside, this monstrosity of law was challenged, alleging that it constituted genocide under its definition in the UN Genocide Convention 1949, to which Australia was a signatory, and thus it should be declared invalid. And let's see how the court responded. Yes, two of the judges literally told the litigants that the law was validly made and thus was constitutional. To hell with the international obligations and human rights.
However, there was another judge, Justice Godwin, who in all her benevolence listened to the litigants and pointed out that the law lacked a fundamental democratic deficit. Basically, that it wasn't passed or approved by the legislators of the state to which it applied. It looked quite well till now.
In a strange and sudden move of solidarity with the Indian Prime Minister Modi, Justice Gordon takes a U-turn and talks about the kind intent of the legislature. She reads the word care, custody, or control in the ordinance as inherently opposed to any notion of genocide. Another Judge Tory actually held that genocide only means killing, and no one was killing the natives. So abracadabra, no genocide, no challenge, get out, thank you.
This is so messed up. The judges literally flipped the colonial logic on its head and argued that the state is actually caring for the natives via the act, and ruled the act of genocide and breeding out of the natives was an act of their assimilation into the beautiful Australian white community. Typical colonial logic, you see.
And now a short hop across the seven seas as we race towards the coast of Newfoundland to ask Dear Columbus, what's cooking? Signing off for now and handing the baton to our sister station based in British Columbia, Canada.
Welcome back to the Canadian Broadcasting Service. I am Romit, Sarkar, and this is Shivam Kataria, our correspondent back on vacation from Perth. I trust you enjoyed your liaison at Perth, Shivam?
Absolutely.
Wonderful. So with that in mind, we now take a look back at our history and mythology, especially that of Wolverine. It's said that in 1985, the government of British Columbia granted the Western forest producers the license to chop timber from the lands of an indigenous group, the Haida, without their permission. A poorly constructed case from the archives, no doubt because when Logan the lumberjack heard of the matter, everything went a little bit scratchy / stabby stab, you know. The government cover-up suggests that a case was lodged in the British Columbia Supreme Court, with Judge McKay presiding.
All this is fascinating, but from what I hear, this was a case which was fought without legal counsel, right? Who on earth would fight without proper representation? This is Mr. Richardson, who was present and was not a lawyer but a clan chief of the Haida.
From what I gather, Shivam, this was their idea of representation, to infiltrate a space of common law with their indigenous presence. An indigenous idea, if I may say so. The Haida did not wish for an adversarial process, much like we saw in Australia in the last segment, didn't we? In fact, the Haida have even argued over the language of the law, or in particular the language the court is meant to use, stating that language for the Haida was not just about words, but a way of life, resulting in a long recess so that they may choose a lawyer for representation in English, which of course they refused.
Seems like they set a mighty good precedent for us. At times in Toronto, I can hardly figure out if I'm in Canada or Punjab. Anyway, I thought this was a case about logging permits, not the idea of a language and dispute resolution methods. It's a question of easements, right?
That indeed, Shivam, is the way the court perceived the matter. Not the Haida, however, who were at pains to stress their distress, the fashion at which they were being denied their duties as caretakers of the land, not owners, they reiterated. They did not therefore want a lawyer to convey their claims as property rights as understood in common law parlance, but wished to explain it themselves through their indigenous system of stewardship of the land.
This is more and more like a fairy tale. The next thing I will hear is that everyone was in costume and that Cinderella lost her crystal slipper. I thought you were one with the land only when you were dead. Ashes to ashes, dust to dust.
Oh, don't be ridiculous. There were no costumes, but there were traditional dresses of the Haida people who wore them to reclaim their authority and legitimacy from the court. This is hardly commented upon and has generally been left unremarked. It's assumed that it was the generosity of Judge McKay who decided not to mention the absurdity of it. But of course, one might consider that if it were mentioned, it would possibly shatter the dignity that the common law courts are based on entirely.
Damn straight. It's remarkable that nobody was slapped with the charge of contempt. Judge McKay had the patience enough to wear a stone down. Looks like he allowed the Haida a voice, to record their defense and preserve it for posterity.
Some favor this white man is doing, recording the death of a culture through the elimination of their language. To be preserved in the annals of the court is an exotic curiosity. seems like a perversion of due process and natural justice to me. Hearing a claim not for its merits, but merely to record the same?
But what about forum non-convenience? It wasn't the burden of the court to adjudicate upon the demise of an entire culture. Common law had its own tradition that could not take into account the defense that was presented in the language of the Haida. That wasn't of the common law.
That may be as it seems, but this also reads to me as an absolution of responsibility of the court, a dereliction of duty, especially when Judge McKay observes that there was no other forum nor remedy left to the Haida. Perhaps in this case, we might want to consider approaching our Prime Minister Justin Trudeau to try and remedy the situation. One can only help that the son can and should make amends for the sins of the father.
In this video, we looked at 3 cases which illustrate how the common law has dealt with issues concerning the aboriginals or indigenous people in 2 of the major settler colonial countries of Canada and Australia. In both these places, the colonizing Europeans have made use of an legal concept of terra nullius, which means no one's land, to refer to the land inhabited by the indigenous people in these places as unclaimed, and thus open to colonization by the Europeans. When faced with questions of atrocities of colonizers, the common law has responded in its usual complicity of furthering states' colonizing projects while absolving itself of any responsibility. It maintains a benevolent facade of public interest institution. When faced head-on with a parallel system of the indigenous jurisprudence, it becomes important for common law to completely avoid any dialogue with such system, as the same would expose its own mythological foundations. Common law would no longer be able to harp on its self-acclaimed scientific rationality, and thus it is necessary for any other system of law or jurisprudence to completely efface itself for common law to maintain its hegemony. And it is in this way the legal language sustains and strengthens settler colonialism with each passing day.
This next song is the story of our experiences of the stolen generation. The system came into my life. Just 150 k's from here to where the sun rises in the east. A policeman arrived on his camel, saw me there with my family, and because I was who I was stolen. This is a song I composed for that time. Apakah jangan you boya kadengo ya my brown skin baby, they take him away. As a young preacher I used to ride a quiet pony round the countryside in a native camp. I'll never forget a young black mother, her cheeks all wet. My brown skin baby, they take him away. Between her sobs I heard her say, police been taking my baby away. from white man boss, that baby I have. Why he let him take baby away? My brown skin baby, they take him out.